Today we're going to talk about conditions precedent. The first question, as always, is going to be what is a condition precedent and why do we have this kind of a provision in the documents? Well, as we've discussed in other contexts, everything has to do with risk in an agreement and how we allocate that risk. Conditions precedent is just another way of doing that. Conditions precedent is our way to establish firmly before we enter into a transaction, before we incur actual obligations, that certain things happen to be true, certain things we've relied on. And if they were not true, then we would not actually engage in the transaction or be willing to incur the same types of obligations. How do conditions precedent relate to risk? Here's how. Conditions precedent are a section of the document where we list out things, both factual and documentary, that have to be shown prior to each party entering into the document and the attendant obligation. The actual conditions precedent section may be broken into two different parts. One, it'll be broken into the types of conditions precedent you need to enter into the effectiveness of the document to begin with, that gives rise to some very preliminary obligations. And two, you'll have a separate set of conditions precedent that will relate to giving rise to the obligations of actually incurring credit events. So in our context, when we're talking about a loan transaction, the first set of conditions precedent will be those that you have to satisfy in order to have the loan agreement become effective and all the related documents become effective. The second set would have to be satisfied prior to you entering into each significant credit event, and a credit event in the context of a loan transaction is typically when you actually loan the money. How does this affect the level of risk? Well, what we populate the conditions precedent section with in the document are the things that we have to see or hear are true one final time without dispute before we're willing to enter into the next level of obligation. An example of a condition precedent for the effectiveness of the loan agreement that limits our risk is we have to actually see the organizational documents of the entities entering into the transaction and proof that they're allowed to enter into the transaction. A type of condition precedent you might find in connection with the loaning of the actual money might be specific asset-related conditions precedent, proof of the value of an asset, making sure it's sufficient to support the money that's being loaned with respect to that asset. And how does this help us with risk? Well, the former, the effectiveness of the document, the level of risk that you're incurring with this transaction is being proven to be as you expected it to be. Therefore, all of the quantitative terms you agree to and the commercial terms you agree to, for instance, loaning the money for a certain interest rate, you're sort of showing that that interest rate is an accurate manifestation of the level of risk for the transaction, because you're understanding that certain things you expected to be true are actually true. The borrower is the type of entity you thought it would be, its organizational documents look the way you thought it would look, and likewise, when you're actually loaning the money, your level of risk is as you thought it would be. For instance, in the asset scenario, you understand that the asset's worth as much as you thought it would be, so that if the borrower were to default on the loan, and you had to collect against the asset, it's actually worth what you thought it was worth, and therefore enough or more than enough, we would hope, to cover the money that's owed to you. So you're limiting your risk through conditions precedent by getting to see without dispute that certain things are actually true. We will spend time in class walking through the actual conditions precedent section so that you can understand the other examples of what a condition precedent is. And like everything, depending on the context, the conditions precedent will vary. I mentioned that there are two typical different types of conditions precedent. Those would be documentary and factual. Documentary are those types of conditions precedent that you can actually produce a piece of paper to prove. whether it is the actual organizational documents of a company or signatures of significant officers of the company, or insurance certificate if insurance is an important part of your transaction. Factual conditions precedent are still conditions precedent, but they are just the requirement that certain things actually factually be the case. For instance, you might require that it's a condition precedent to the transaction that there have been no material adverse change in your borrower's business since a certain date. That date usually relates to the last time that you were able to kind of properly diligence the company or see properly audited financials of the company. Whether or not a material adverse change is true is a factual question. The borrower will have to tell you that it's the case in order to proceed with the transaction. The lenders, if they did not want to proceed with the transaction on the basis of the material adverse change condition precedent not being satisfied, would have to tell the borrower that it did not accept that the condition precedent was actually satisfied. And then if there was actually a difference of opinion on that factual question, there will be further discussions, and in the worst case scenario, you might end up in a litigation scenario. So the documentary and the factual conditions precedent are what these things are usually broken down into. Now, when we're actually practicing, we are responsible for providing, reviewing the documentary conditions precedent. The factual conditions precedent will be the borrower's responsibility to satisfy. There's often a certificate given where they say that these things have been satisfied. But we as lawyers usually just make sure that the document includes those CPs. If there's an agreed certificate to be given, that it's been properly given and it includes the proper substance. But otherwise, we as the lawyers assume that the borrower is considering that CP satisfied and that the lenders see no issue with that CP being satisfied from a factual standpoint. As far as the process for how this works, the idea of collecting conditions precedent, reviewing conditions precedent, negotiating conditions precedent, a lot of this actually falls on the younger associates. So you will find that in practice, in your first and second and third year, you'll spend a good deal of time taking a look at these conditions precedent. So this is particularly relevant for you. And actually, one of the things you may have seen already in your own experiences, and you'll certainly see when you get back into practice, is the relationship between conditions precedent and a closing checklist. Many of you might have worked on a closing checklist in a summer associate position or in some other context. I often find that we neglect to mention where all of the things in the closing checklist actually have come from to our younger associates when they're just starting out. It's a quick, easy answer, and perhaps that's why we sort of forget to mention it. But just so you know, when you're looking through a closing checklist, those things come from somewhere. There is a logic behind the closing checklist, and it's the conditions precedent that are included in a document. In the larger transactions where there are several documents, normally you would have conditions precedent contained in one single document that apply to the entire transaction. But occasionally there'll be conditions that pop up in other documents in random spots, and we have to keep track of all of those things. The closing checklist is the way that we do that. Once you start receiving conditions precedent in connection with the closing of a transaction or an upcoming credit event for a transaction, you'll be reviewing those things. There are a couple different levels of review. There's a very superficial level of review, which is simply saying, did I receive this condition precedent? Yes, I did. No, I didn't. And then there's the deeper level of review, which is the most important, and that is, yes, I received it, and it says and looks exactly as it should. So that's the type of thing that you'll start looking at. How do you decide whether something says and looks like it should? It's going to be based on what's required for the transaction, what the documents say it should look like, and then also what things customarily look like. So you'll be relying on looking at precedents and comparing your current conditions precedent to the precedents. Once you've reviewed a condition precedent, if you have comments, you typically send it back to the other side. and then they'll agree or disagree with the comments, and you'll enter into kind of a negotiation process over that. Normally it's not an extensive or particularly heated negotiation. It should always be governed by practical considerations and pragmatism, as in how resource intensive is it to satisfy some of the comments. Is it possible? If it's not possible, is it for something that's does not increase your level of risk if it's not modified the way you'd like it to be? And so you go through this negotiation process. If a condition precedent cannot be satisfied in time for the scheduled closing, there are a few things that can happen. One, you can postpone the closing, but that's normally a pretty significant deal, and people don't like to do that if they can avoid it. But if you cannot postpone the closing and people are satisfied that the lack of satisfaction of that condition precedent at that time is not a material change in the level of risk of the transaction, then you can either waive or defer the CP. A deferral of the CP simply means that you'll convert the condition precedent from a condition precedent to a condition subsequent, which we'll talk a little bit more about in just a second. The waiver of a condition precedent means that you have agreed that you don't need to receive that condition after all, which means you'll never receive the condition. You can do that for many reasons, but you obviously have to be satisfied that it doesn't change your risk in a way that you're particularly concerned about, and you're happy to move forward with the transaction despite that condition not actually being satisfied. I mentioned a second ago condition subsequent. Like I said, a deferred CP can be converted to a condition subsequent. You also can negotiate certain things as conditions subsequent. Like conditions precedent, there are conditions that have to be satisfied, but instead of happening before the obligations have been incurred or before credit events have been incurred, these have to be satisfied after. The question of why would you let that be the case may come up, and what do you do if you don't satisfy these things? And those are good questions. The reason we have conditions subsequent in the case of non-deferred conditions precedent is because certain things can't be done prior to closings or prior to other credit events, and all parties understand that that's the case in certain circumstances, and so you'll require that something happen post credit event, but typically within a period of time. Failure to satisfy a condition subsequent should be tied to some sort of a consequence in the document, so that if it doesn't happen, the lenders actually have some sort of remedy or recourse that they can rely on, so that they aren't left in a situation where they've incurred obligations, they've loaned money to the borrower, and the condition subsequent's never satisfied or not satisfied in a timely manner, and the lenders don't have any way to kind of protect themselves in that scenario. For the deferred condition precedent that is a condition subsequent, likewise, you typically have a separate, very brief agreement that defers the condition precedent, and you should tie it to a timeline and tie it to recourse or remedy if it's never satisfied. That wraps up the brief summary and review of conditions precedent. We're going to discuss this further in class, but it does give you sort of a foundation to operate on, and we'll take a look at these in the document so you'll get a sense. But once again, conditions precedent are one of our critical risk mitigation provisions. And again, we've negotiated an entire transaction at a commercial level. Now we're documenting that transaction, and the conditions precedent are the section of the document where we're really going to make sure that we've seen proof that all of the things that we've relied on as being true in order to determine the relevant level of risk for the transaction, which we deem to be acceptable to us, is actually the case. So that's it for this section. Look forward to seeing you in class. Talk to you soon.